Well, hello, everybody, and welcome to today's webinar. My name is Heidi Salati, and I am the Director of Education and Training for PHCC National. Today's webinar is Marijuana in the Workplace. So before we get started, I did want to let you know that your mics are muted, but we do encourage questions by using the chat box in the lower right-hand corner of the GoToWebinar window, and then we've left time at the end to answer your questions, so please be sure to type them in. Today's presenter is Sarah Turner. Sarah is a partner with the law firm of Gordon and Reese, Scully and Maniscalco with the Employment Labor Group, and she is located in Seattle and the Portland office as well. So thank you, Sarah. I'm going to turn it over to you.
Thank you, Heidi. Welcome, everyone. As Heidi said, my name is Sarah Turner, and I am a partner with Gordon and Reese, Scully and Maniscalco's Labor and Employment Group. And I have been speaking at length for a couple of years now on this topic of marijuana in the workplace and advising and counseling employers and businesses on how best to respond to this new cultural and social development that's occurring in our country and is continuing to move forward. I speak on this often, and I am constantly updating my notes and presentation because the laws and the states that are signing up for legalizing marijuana, and either as medicinal or recreational, is the landscape is ever changing. So today we will address many of the issues, concerns that have arisen. Being here in Washington, we've been doing this since 2012, and so I have a good idea of what is appears to be successful and what may not appear to be successful, and I'm here to tell you that the businesses and employers in Washington and Oregon, for that matter, are proceeding as they have always proceeded, and we're not really seeing this to be a real issue as of yet, I guess I can say. We'll begin. So as I said, we'll cover the legalization of medical and recreational marijuana use that is rapidly happening across the nation, and how the legalization is changing the workplace as to workplace safety, drug testing, and performance management. So this graph is always being updated. This is, where is marijuana legal? And if you recall, in 1936, there was the movie Reefer Madness, which was a propaganda film released to warn Americans of the dangers of marijuana. And the film targeted students at a high school where the students were lured by quote-unquote pushers, and after taking a hit or two, the otherwise innocent students are now involved in a hit and run and manslaughter and suicide, hallucinations, and becoming generally just insane due to their quote-unquote marijuana addiction. It is amazing to me how far we have come in 83 years. And in 2019, there are now currently 44 states that have legalized marijuana either for medicinal, recreational, or both. And Illinois is the most recent state as of June 25th, 2019, to legalize recreational marijuana. So as of now, we have 33 states in the District of Columbia with legalizing medical marijuana, and California was the first of the states in 1996 to legalize medical. Recreational use, we have 11 states in the District of Columbia, Colorado and Washington being the first states to legalize recreational marijuana in 2012. And then, as I just stated, Illinois has become the 11th state in this past month. Now, there's also the CBD products, which is the THC content in marijuana that is being extracted and used for products for all host of things, for headaches, arthritis, being made into creams, and and 14 states have a limit on the THC content and allow access to products that are rich in the cannabidiol, which is the non-psychoactive component of cannabis. This slide just demonstrates the states where marijuana is legal. It reflects the same thing which was in the first slide, and again, highlighting Illinois joining these states. To note, Alabama and Mississippi have additional restrictions to the medical use, and Louisiana will only allow oils and topical applications. They're right now appear to be the most restrictive of states who have some form of legalization. So it has what I've coined as the banner year for legalization by the state legislatures. And noticeably, there was a lot of resistance by many states, several years ago. And it is interesting how these states are now changing their position. And for example, in New Hampshire, the governor decriminalized marijuana, but states that's as far as he will go on the legalization front. However, the Democrats took control of both chambers, and there is believed to be enough support now to override the governor's veto. And in New York, Governor Cuomo, who flipped from calling marijuana the gateway drug to advocating that it is now time to legalize recreational marijuana, he has created a task force whose only objective is to draft the cannabis legislation, and he has directed the state's health department to study it. The resulting report concluded that the positive effects of ending cannabis prohibition outweighed the potential negative impact. So it appears that New York will be following suit shortly. Rhode Island is reluctantly legalizing after Massachusetts and the anticipation of Connecticut legalizing the recreational use of marijuana. And then Vermont, interestingly, legalized possession in 2018 and the home growing of small amounts, but the current law does not allow for any form of commercial production and sales. So this leaves Vermont as the only state who has it legal but is not receiving any tax revenue or mechanisms to regulate its trade of it. And so that is something that we believe will be corrected by the state legislatures in 2019. I also have here some predictions for 2020. And as you see, I predict that legalizing medical marijuana will be Kansas, Wisconsin, Mississippi, Nebraska, and South Dakota. And these predictions stem from comments that governors and state legislatures have made to the media that have been picked up. In Kansas, the governor supports legalizing medical marijuana. So presumably as soon as the bill is before that governor, that will be legal. Similarly, in Wisconsin, the governor supports decriminalizing marijuana, legalizing medical marijuana, and letting the voters decide by referendum on the recreational use. As for Pennsylvania, is looking into decriminalization of the marijuana. The governor who's opposed it is now open to taking a serious look at this issue. But right now in Pennsylvania, the governor is only interested in decriminalization of marijuana and not going any further. As for legalizing recreational marijuana, Arizona was one of the more recent ones. We have Florida, Ohio, and North Dakota, who we anticipate through the state legislation will be legalizing recreational marijuana. I cited Arizona when I spoke there most recently, so it became quite familiar, but it looks like that is definitely headed to the ballot in Arizona for this next round of elections, and it's anticipated to pass. So I suspect Arizona will be following Illinois as the next state. As for a notation here about Texas, the governor supports the decriminalization, but there are advocates that are heavily pushing to legalize medical marijuana, and it's a growing number. So we'll see what Texas does with this. The local activist movement that I've noted here with Texas and South Carolina. South Carolina is going through the same kind of experience that Texas is going, where the advocates are pushing really hard for legislation on legalizing medical marijuana in South Carolina. So we'll see if they are effective. So here's the big question: why? Why are states now on board when 83 years ago everyone was being told that if you smoke marijuana, you're going to commit homicide or suicide or go crazy? And that's not a long time, only 83 years ago. So what has happened? Well, beyond scientific studies and showing benefits of marijuana for medicinal purposes, it always comes down to money, and it is revenue, and it is a revenue-driven product. Just to give you an example, I use Colorado and Washington's revenues here, and then what the governor anticipates will be bringing to that state. So in Colorado, in August of 2018, marijuana sales exceeded $1 billion, with tax revenue from those sales of $200 million. The marijuana total sales for the fiscal year of 2017 was $1.5 billion. In Washington, in my state, $319 million in legal marijuana income and license fees for the fiscal year of 2017. The sales have steadily increased from $259 million in fiscal year 2015 to $1.3 billion for the fiscal year of 2017. Those are just outstanding numbers, and all the states that do not have a legalization of recreational and/or medicinal are looking at these numbers and seeing how more revenue can be brought into their state. And this is demonstrated by Illinois, who anticipates 24,000 jobs, $500 million tax revenue, and infuse $1 billion into the state economy by 2020. So I first want to talk about the federal law and compare it to the state law and what is allowed and not allowed under both federal and state. So under federal law, the use and possession of marijuana remains illegal, and it is classified under the Controlled Substance Act as a Schedule 1, which is the same classification as heroin and LSD. When Obama was president, the Rohrabacher-Farr Amendment prohibited federal prosecution of individuals complying with the state medical cannabis laws. And then prior to January 2018, the Cole Memorandum provided protections against the enforcement of federal law in states that had legalized marijuana. And that was a law that had been in place when Obama was president, but then it was rescinded by then Attorney General Jeff Sessions, who is a staunch opposer to legalizing marijuana. And since he rescinded it, it has not been put back into place. So right now there aren't any protections for states. However, with Jeff Sessions out of not being Attorney General anymore, the states have relaxed a little bit because there hasn't been any federal enforcement of the federal law in the states where it's legal. So it's been pretty quiet. And the rumor is that President Trump is looking to have federal law recognize marijuana as a legal substance closer to the election time. The the discussion out there is that he's hoping to bring in the millennials to vote for him if he, quote unquote, legalizes marijuana for the federal government. So, under federal law, excuse me. So we'll see how that plays out. But to that point, there is currently 3 different proposed statutes that are going before Congress right now. One is the Compassionate Access, Research Expansion, and Respect States Act, and this is a House bill. I apologize, this is a Senate bill, and it is will allow the states to establish their own medical cannabis programs without federal intervention, and it also would prohibit federal banking regulators from terminating or limiting the deposit insurance of a depository institution solely because it provides financial services to marijuana-related legitimate businesses, or penalizing marijuana-related legitimate businesses, which is huge because the banking regulation, the banking has been a very difficult issue to get around for the marijuana producers and growers and sellers. So this would alleviate that. The also important part of this is that it would require that the VA, of veterans, that those medical providers from the VA would be allowed to recommend medical marijuana as a recourse to any ailment that an individual is having. There's also the Legitimate Use of Medical Marijuana Act, and that is being sent out by the House, and that would legitimize medical marijuana in accordance with state law and reschedule marijuana under the CSA from a Schedule 1 to a Schedule 2. And then you have another House bill, which the Regulate Marijuana Like Alcohol Act, which would remove marijuana from a list of controlled substances altogether. So it would not be deemed at that point to be an illegal substance. And so right now those are just pending. We don't know how they're going to play out. I suspect a form of one of these will be enacted, but that is something to keep your eye out for. So state laws, however, vary as to whether an adverse action may be taken against an employee for engaging in off-duty marijuana use that's legal under state law, and whether the employer has an obligation to accommodate that off-duty medicinal use. Consideration of the particular circumstances is needed before the adverse action is taken against the employee or candidate for legal, medical, or recreational use, and there's guidelines for the employers to follow. So when you have this conflict here between the federal law and the state law, where the federal law says it's not legal and the state law is saying it is legal, what is an employer supposed to do if you want to continue to enforce your zero tolerance drug policy, or you're an employer that has federal contracts? How are you supposed to handle this? So here's some guidelines. An employer may prohibit marijuana use for the following circumstances. 1, your DOT compliance. So for physicians regulated by the Department of Transportation, such as those requiring the commercial driver's license, employers must adhere to the Omnibus Transportation Employee Testing Act of 1991, regardless of state law. And this act mandates that all employers drug test employees whose duties necessitate a commercial driver's license. The DOT's Office of Drug and Alcohol Policy and Compliance does not recognize medical marijuana as a valid medical explanation for a positive drug test. Quote, it remains unacceptable for any safety-sensitive employee subject to drug testing under the Department of Transportation's drug testing regulations to use marijuana. So if you're an employer and you fall within this guidelines and you have to comply with, you will be protected from any claims by an employee that they were wrongfully terminated for testing positive for marijuana, for having a medical marijuana card, and for not accommodating. As of right now, with the federal government's position, you would be protected. There's also the Federal Contract Compliance and the Drug-Free Workplace Act, which applies to certain federal contractors and grant recipients who, and it requires a continuous good faith effort for companies to maintain this drug-free workplace by publishing or distributing a policy, specifying actions for the policy violations, providing education about drug use, and providing employee assistance programs for those who are struggling with marijuana or other drugs. The law provides a basis for a zero tolerance policy. So if you fall within this, then you would also be protected from claims alleging wrongful termination under under state law. Outside of federal statutes, the use and impairment in the workplace can be prohibited. Although there is decriminalization of marijuana is increasing, none of the medical or recreational marijuana laws require the employers to allow employees to use, possess, or be impaired by marijuana during work hours or in the workplace. And that's true even if for medicinal purposes. So it's similar to the company's no alcohol use policy. And this is a question I get often, which is, well, if they have my employee has a medicinal marijuana card, then that person, they're telling me they can smoke a joint during a break. And the answer is absolutely not. There's not one law out there that says that an employee or a person has the right to possess or use marijuana while working or outside of their private home. Some states, Washington is very specific about you can't use while on the street or in the public space, but you can at your home. Interestingly, you can possess while you're on the street, and it's an absurd amount that you can possess on you under Washington law, but you can't use. Now, I will tell you right now that that is being just given a nod to, and that it is very obvious on the streets of Seattle that people are using, and it's not being monitored by the police. But the law says it's to be in the possession of your house. So there's nothing, no laws that I have seen that say the employers have to allow their employees to use it while at work. None of these laws also place restrictions on an employer's right to administer drug tests, but the states may have separate laws regarding how to use the results from those drug tests. So that's what you need to be cautious about. So now recognizing impairment. Currently, there's no reliable metric for determining when a particular level of THC from marijuana usage impairs the user and for how long that user remains impaired. So generally, THC is a compound that has the ability to stay in someone's system for up to 30 days. And to put that in perspective, alcohol stays in your system for hours. Amphetamines and cocaine, they are in your bloodstream. I believe the longest is 3 days. I think cocaine has a shorter time period than that. So the point being, someone could smoke some marijuana on the first of the month, and at the end of the month be tested, and there still may be some THC in their system, even though they haven't had any, had any marijuana since the first of the month. And so how is an employer supposed to handle that? Particularly because that does not mean that the user is impaired at the time that the drug testing is occurring. So a lot of my clients have simply stopped conducting pre-employment drug testing for marijuana, and will only drug test for marijuana if there's an accident or for under reasonable suspicion that there appears that the employee is impaired at work. And so they are learning how to first evaluate the behavior, and then if the drug test is conducted, then they're treating it only as supporting evidence that this person was impaired at work. So I had a client actually do this a couple of months ago. It was a night shift, a graveyard shift. Person was, according to the supervisor, stoned, was just bloodshot eyes, was just very lethargic, was out of it, and sent him immediately for a drug test, and the levels of THC were very high. And so this person was disciplined for violating the drug policy, and ultimately admitted that yes, he had smoked some pot before coming to work, and so it's a balance, and we don't want the employers to start becoming medical doctors and trying to identify whether or not someone has a condition or not. But that is kind of how we see this being managed right now. The higher level of THC is an indicator of more current recent use of marijuana. Now, there are state courts that have issued rulings in favor of the employers who've taken adverse actions against the employee based on his or her legal marijuana use. And the courts have relied on federal law and looked at the state's own marijuana law. So, for example, California and Colorado, when they've been challenged with, when employees have challenged their termination, California and Colorado rely on marijuana use being illegal under federal law to allow employers to take adverse action against the employee. Now, I'm going to say right now that this view is shifting, and I'm going to get into what I mean by that. But there's definitely a shift on how employers are to look at medicinal marijuana and accommodation issues, and that is where I foresee we're going to start having the lawsuits and the case law beginning. But hold on that for a minute. Under Washington, when our courts have had to evaluate this, the Washington courts relied on the language in the marijuana law that explicitly in Washington states that the law is in effect simply as an affirmative defense against criminal action. So our marijuana law here was more of a decriminalization act than any other purpose, although it did legalize marijuana. The whole purpose of it was to decriminalize it. So drug testing, employers are empowered to act upon observing signs of impairment. This is true for any type of impairment, marijuana, alcohol, prescription drugs. In addition to acting upon signs of impairment, employers are allowed to conduct drug testing for certain positions, such as safety positions, and not others. So you can isolate certain employees for drug testing and not others, so long as they're all for the same position, such as a safety position. And that everyone in that position is treated equally, and there's prior notice that the employer is going to conduct the testing. Employers may take adverse action for an employee's legal off-premises use in accordance with the company's drug policy. So a wrongful termination claim is not created for employees who have been discharged on the basis of their marijuana use, even if it's on the basis of medical marijuana use to treat a disability. And I highlight that's with exceptions, which we will get into. To highlight some of the case law coming out related to protections that employers have had. There's a California Supreme Court case, Ross versus Raging Wire Telecommunications, held that an employee did not have the right to sue their employer for terminating his employment based on off-duty and legal medical marijuana use. That's great for employers. They relied upon the California's disability discrimination law did not require the employers to accommodate the use of drugs that are illegal under federal law. And this is right here where everything is changing, because California right now is reworking the statute, so that's ultimately going to require employers to accommodate medicinal marijuana use. And they're just following suit from Massachusetts, which is the state that started the accommodation issues. But still staying on the benefit for employer case law, in Colorado, Coates versus Dish Network, the employee who used medical marijuana sued the employer for terminating him based on the off-duty participation of a lawful activity. And the court said, you can't sue the employer under the federal law because it prohibits marijuana use in all states. Therefore, the employee could not prove that his use of medical marijuana was truly lawful. In my state, Washington, we have a case, Roe versus Teletext Customer Care Management, where the Roe's hiring was contingent on passing a drug test. She started her employment while the drug test was pending. Roe notified the employer of her legal medical marijuana card, and she complied with the drug test. But when she tested positive, she was terminated. And the holding was, under Washington's medical marijuana law at the time, provided an affirmative defense against criminal prosecution of physicians for prescribing medical marijuana and of qualified patients and their designated primary caregivers for engaging in the medical use of marijuana. And the court declined to extend the public policy for protecting individuals from employment action. And to date, Washington does not have any plans to rewrite the statute for accommodation purposes, but I simply believe that's because they've been busy rewriting other employment laws in the last couple of years. So I suspect Washington will be also rewriting their accommodation laws or to add accommodation in the next coming session. So there are some states where medical marijuana laws explicitly offer users protection from employment discrimination use outside the workplace. And there are also states that prohibit employment decisions based solely on the person's status as a medical marijuana user or card holder. And the state abbreviations in red are those states that fall into one of those categories. Positive tests for medical marijuana will not result in adverse action unless the individual used, possessed, or was impaired by marijuana in the workplace or during work hours. Exceptions from the employment protections include safety-sensitive positions and or when it would result in the loss of a business license or a government contract. That is language that the states highlighted here have all generally used, with some small differences here and there, but this is a summary of what all of those statutes are saying with the protection that they're providing the employees. With regard to employees in states with legalized marijuana, we are always advising that a company consult with legal counsel when adverse action is going to be necessary, and it's adverse actions related to the marijuana use. It's just we really highly recommend that you consult with your employment counsel or your HR department before any decisions are made. So the duty to accommodate, this is the big question. Again, under the Americans with Disabilities Act, which is a federal statute, there is no duty. There hasn't been a duty, there remains no duty. And in most states, there's no duty to accommodate medical marijuana. But I can't stress this enough, that is changing, and it's changing and shifting quickly. So, for example, there is a duty in Massachusetts, Rhode Island, and Connecticut. And Massachusetts and Connecticut are the ones that started the accommodation discussion. In those states, the employers must engage in an interactive process to determine whether the medical marijuana user can be accommodated, which could include as an accommodation discounting the positive test for marijuana. Nevada prohibits employers from denying employment to a prospective employee because that employee tested positive for marijuana. That Nevada law just passed, I believe it was in April of this year. Interestingly, Maine is the only state that provides protection for recreational users. I have their statute right here. An employer may not discriminate based on the status as a medical or recreational user unless it would cause the employer to violate federal law or lose federal contract or funding. But employers you're still not required to allow the employee to smoke at work under Maine. And then the protection provided to recreational marijuana users in Maine. Employers may not discriminate against applicants or employees based on purely off-duty marijuana use. However, employers are not required to accommodate use or possession of marijuana at the workplace and may discipline employees who are under the influence. So under Maine, you just simply can't discriminate and not hire someone or take adverse action against someone because you find out that they are a user of marijuana. This is a list of states with statutory protection for medical marijuana use. And again, I highlight Illinois and Nevada because they're the most recent ones who have either legalized or have had a statute put into effect. You have Arkansas, Arizona, Connecticut, Delaware, Illinois, Maine, Minnesota, Nevada, New Jersey, New Mexico, New York, Oklahoma, Pennsylvania, Rhode Island, and West Virginia. You then have state courts protecting medical marijuana users at work. So this is different from the statutes that your legislatures would have drafted. This is the state courts taking a position. And as of now, California, Colorado, Michigan, Montana, Oregon, and Washington have no protection for medical marijuana users at work. You don't have to accommodate them. But Massachusetts and Connecticut have protections under decisions authored by the courts there. But again, California, Colorado, Oregon are actively currently revising legislation for accommodation. I believe Washington will follow suit next year, and I suspect actually that all states will be using the similar language that we're currently seeing. This is the two cases from Massachusetts and Connecticut highlighting the court's position. Under Barbudo versus Advantage Sales and Marketing, the Massachusetts Medical Marijuana Act, quote, implicitly recognizes, unquote, that allowing off-site use might be a permissible accommodation for disability under the state's anti-discrimination law. And then Knopfsinger versus SSC Niantic Operating Company, Connecticut's medical marijuana law specifically prohibits employers from taking any adverse employment action against an individual based on his or her status as a qualifying patient who is authorized to use medical marijuana. So Connecticut's court relied on their statute to get to that decision. So how is employers supposed to handle this duty to accommodate that maybe either currently exists in your state or very well will be in the next few years? Again, under the ADA currently, unless Trump does change it, under the federal ADA, a person who is currently engaging in the illegal use of drugs is not a qualified individual with a disability. The Federal Controlled Substance Act describes marijuana as use as illegal. Therefore, there's no federal protection for an individual currently using medical marijuana, even if the individual's use is compliant with his or her state's medical marijuana laws. How does this help employers? unless you have to abide with the DOT or with federal contractor laws that we talked about at the beginning of the webinar. This is nice to know, frankly, but in practice, if an employee wants to bring a case and they just won't bring it under the ADA, they'll bring it under your state law. So practically speaking, it's not you can't circumvent the issue here, but it is still a true fact that under the Americans with Disabilities Act, medical marijuana use is not to be accommodated and does not provide the employees any additional protection. Employers in such states, we recommend, should engage in the interactive process with the employee who discloses that they have a disability or medical condition and use medical marijuana for that disability or medical condition to evaluate the employee's ability to safely perform the essential functions of the job with or without reasonable accommodation. So duty under state disability laws. The duty to accommodate or not is found in the language in terms of your respective state's discrimination and marijuana statutes. States that protect the medical marijuana users prohibit refusing to hire or terminate an employee who discloses their medical marijuana use. And there's an exception of safety-sensitive jobs, safety-sensitive positions. The states that prohibit off-duty use because the workers in these roles must have full use of their skills and faculties while performing their jobs. So what this means is you don't have to accommodate someone who's in a safety-sensitive position, even under your state laws that say you do, or that you have to accommodate medical marijuana use. You don't for someone who's in a safety-sensitive position. And that's because these negative effects of use could include impaired motor performance, impaired mind, loss of balance and coordination, decreased attentiveness and alertness, prolonged response time to stimuli and danger, decreased ability to judge distance and space, and an impaired ability to perform complex tasks. So when an occupation is designated as safety sensitive, it's permissible for the employer to inquire whether that employee is currently taking any prescription drugs or medications, whether the employee has taken any such drugs or medications in the past, or monitoring an employee's taking of such drugs or medications. So what is a safety-sensitive position? This is a position in one which job performance can affect the safety of the employee and others. So your truck drivers, forklift operators. The employer, however, you must be able to demonstrate that the employee's inability or impaired ability to perform their job could result in a direct threat to his or her safety and or the safety of others. Here's just a list of safety-sensitive positions: driving motor vehicles, working with power tools, operating equipment, working on elevated surfaces, the construction industry, the security guards, or any industry that may involve weapons, or and this may seem obvious, but it comes up too much in my discussions with clients or through webinars, so I felt compelled to add it, which are office positions, your receptionists, your controllers, your HR. Those are not safety-sensitive positions, at least under how the term is used in this context. So I have had employers say, well, I'm just going to designate all of my positions here at my factory as safety sensitive, and now I can test and we're good to go. And I need to kindly remind that person that no, you do have office employees and you are no way going to be able to establish that those are safety sensitive people. So it is not a complete carve out for you as an employer, but it is an important one if you do have, if you're in an industry where you do have these types of jobs, and it's important to know that those people can be tested, and the medical marijuana doesn't need to be accommodated in that position. You should probably still engage in the interactive process and identify if there's another position that they're better suited for while they're actively using medicinal marijuana. Alcohol and drug-free workplace policies, including drug testing procedures, which prohibits impairment by alcohol or a controlled substance, legal or illegal at the workplace, are generally recommended to still have and to do the following. Remind your employees of the company's zero tolerance for on-the-job impairment. Train managers and supervisors to identify signs of impairment, and manage the employees' expectations. When Washington's law went into effect, there were so many calls saying that I received where the employer was had learned that an employee during a break was, smoking, but was smoking joint, not cigarettes, and that this person thought they had the right to do that. And it was a little confusing, I think, the way the Washington law was rolled out. And so I spent a lot of time with my clients training and meeting with the employees and kind of explaining what the law meant. And so a lot of it, I think, is just, especially if you're in a state where it's a new implemented law, a lot of it is just really understanding and learning what the law means. And I highly recommend that you meet with your employees and go over it and really what it means. And it does not mean that they can be under the influence while at work. Here's just a laundry list of examples of impairment that your supervisors, managers should just be aware of. And this is not limited to just marijuana. I mean, these could also show signs of impairment of alcohol or another type of prescription drug or any other type of drug. But these are generally the ones highlighted by law enforcement for marijuana. Your drug policy and testing procedures should be consistently enforced. And I have here some recommendations and best practices. And for the safety-sensitive positions, I cannot stress enough that you need to, on the front end, designate what positions are safety-sensitive, and make sure your written job descriptions reflect that this is a safety-sensitive position. It should just say it right there, and how impairment would pose a safety risk. You should also include in your job description a notice of potential drug testing for the safety-sensitive position, and that the respective position is considered to be a safety-sensitive position. Again, no surprises. This person's applying for the job and they use marijuana for medicinal purposes. They need to know right now that maybe this isn't going to be the best job for them because it is a safety-sensitive position. They will be tested, and it's an exception to the accommodation. So maybe there's another job that they can apply for that doesn't fall within the safety-sensitive position. But it's all about providing the notice. And then always, offer the employee assistance where appropriate. If they need to take a leave for drug or alcohol rehabilitation, that should be allowed. If you have an employee assistance program, make sure people have that information in case they need to use it. Engage in the interactive process when discovering an employee using medical marijuana for a medical condition. It's just that's where employers, in any run-of-the-mill disability case, employers find themselves in trouble most often. So just continue to engage in the interactive process, even if you're not in a state where you necessarily have to accommodate it yet. I just recommend getting into the practice of doing it because it will eventually need to be accommodated. Evaluate the employee's ability to safely perform the essential functions of the job with or without the reasonable accommodation, and then remember your safety-sensitive position exception. Another best practice is just being aware of the states who are or will be legalizing medical and recreational marijuana in the future, especially if you're a business that has locations throughout the country or throughout a region. Recognize that state marijuana laws are not the same. A lot of them have similar provisions, but they're not the same. Not each one is very individualized and affords different protections for their citizens. And an example is some states provide employment protections related to marijuana use, while with the safety-sensitive position exception, while other states offer no protection for employment. Also remember, drug tests are not reliable for marijuana to establish whether the employee is truly under the influence. So a recommendation is revising your drug and alcohol policy to state that employees will be disciplined up to and including termination when the employee is found to be displaying behaviors, and I think that's a pretty key word there, consistent with being under the influence and test positive for marijuana. So the test, again, and you would be looking for a high level of THC because that is going to show that the marijuana was ingested more recently, and if they're showing signs of impairment, most likely they are under the influence. And I did pretty good. So it's time for some questions if we have any. Heidi?
We did have a few, but you answered several of them already. But there is one that came through, and I think you did touch on it, but maybe just reiterate it a bit. And somebody had asked about what about the customer service reps? They communicate with the customers, and if they are impaired, they can hurt the business. You could lose business. Complaints can be filed. So I think what we heard was, in this particular industry, you don't have to be a plumber or a tech or an HVACR person to really have a drug policy enforced. It goes across the board to anybody in the office, from a customer service representative to the tech that goes into somebody's home. But is there anything, any more specific that you can say about those who are office management or office employees that are not going out in the field?
Sure. So, and this really kind of goes towards the, do we have to accommodate? And so for right now, let's take the states where they're saying, as an employer, you do have to accommodate medicinal marijuana use if it's for a medical condition or a disability. And again, the exception to that is the safety sensitive position. So clearly, you have an office manager or office personnel they're not going to fall within that safety sensitive exception. So yes, now you have a duty to accommodate, but it's a duty to accommodate means such as you can't not hire that person because they show you the medicinal marijuana card. If you have to weigh what it is when you test, if you were to test them for marijuana, are you just testing them to see if they've smoked marijuana or not, like in a pre-employment setting, or are you testing them because you are suspicious that they are under the influence? And the accommodation laws are saying, while you have to accommodate their card and the fact that they're using, you don't have to accommodate them being under the influence while at work. And it's going to be a little bigger burden to establish that in the states where there is accommodation laws, but you don't have to accommodate anyone using and being under the influence currently while at work. It's just how you establish that is the more difficult part.
Okay, thank you very much. That was helpful. And I'll give it just another minute to see if any other questions come up. If anybody has any questions specific to the state that they live in, if Sarah hasn't already covered it, let's just give it a few seconds. Okay, Sarah, so I think I am going to wrap this up. If anybody does think of any questions after the fact, send me an email and I will do my best to get an answer for you. So I do want to thank our speaker, Sarah Turner, for providing this very informative webinar for us today. And we will hopefully see you next month on our next webinar. Thanks, everybody, and have a great week.